The Deputy to move.
I move. Thanks, Lascan. Well, as the Minister knows, the exceptional needs payment fulfil a very, very important role in our society. It's a relatively small amount of money, a tiny amount of money actually from the total social protection budget. I think in 2017, the Minister told me on November 7th, the total budget for single exceptional needs comes to 31.5 million. And I noticed that over the year, you generally would have, I know it was November last year, 9,400, the number of payments. December was 9,100, and all through 2017, you're roughly around 8,000–9,000 per month of applicants secured an exceptional needs payment. One of the things I noticed, though, with the Statistics Minister, which Minister Doherty told me on November 7th, is that the statistics on the number of people and families who are refused is actually not kept. So we can't look globally and saying this number, say 100,000 or whatever per annum, what percentage that would be of the total amount. And I think that's a lacuna, because exceptional needs gives us an insight into the stresses that our citizens and families are suffering, particularly in the period in which we're going now, the pre-Christmas period, when there'll be all those additional stresses, the cold weather, the heating payments for clothing, and so on and so forth. Now, it's a demand-led scheme, of course, as the Minister told me in her reply. But what I've been finding myself in my own information clinics is that people who were in these kind of situations, having an exceptional need at a particular time for the family or themselves, are being increasingly refused. And they're being refused on the basis that the guidelines that your department has issued to its officials and deciding officers stress that the need must be exceptional and unforeseen. Now, we would contend that there is no basis in the legislation for that. And I went back to have a look at the 2005 Social Welfare Consolidation Act, which is section 2001. And it says that, and I quote, "A designated person or deciding officer may, in any case where the designated person or deciding officer considers it reasonable, having regard to the circumstances of the case, so to do, determine or decide that supplementary welfare allowance, SWA, shall be paid to a person by way of a single payment to meet an exceptional need." And I want to add the words, an exceptional need, which is not necessarily unforeseen. As I said, I want to do that because that's been the experience, and it's been the experience of, I think, other representatives as well, and agencies who work in the area to try and protect our most vulnerable families. I've seen the example, for example, of perhaps somebody's grandmother who was sick, and the issue then arose, who had a fatal illness, the issue arose then about funeral expenses, and the example was given that this was an exceptional expense for the family, but not an unforeseen expense. And the test really in the legislation in 2005 is that the needs, the requirement for the payment is exceptional conditions. And what we believe has happened here is that a further hurdle effectively is being erected by the department to make it that bit harder, and that the interpretation of the department in this matter is incorrect. The statutory test certainly is one of exceptional, and to add the statutory test to a further hurdle of unforeseen, I believe, is unlawful. And we also have a judicial decision by Hogan J, where he gave an explanation of the meaning of the word exceptional in the case of Mackey versus Residential Institutions Redress Board in 2016. And from that decision, I think it's clear that exceptional means, and I quote, "exceptional circumstances simpliciter," end quote, with the standard of exceptionality measured by reference to contemporary standards prevailing within the general public. So if someone has a serious illness, illness needs a once-off payment for a winter jacket, they are exceptional as per the ordinary meaning of it. If you try to argue that this is not unforeseen also, then effectively, your Minister and the Department is changing the rules. And I think the starting point for many people would be that exceptional and unforeseen are two separate concepts completely. But in the Oxford English Dictionary, it is clear that they don't overlap in their meaning. So the question you'd have to ask is, can something be exceptional and also foreseen? The answer, Minister, is of course yes. It means obviously that the DEASP rationale it is incorrect because, as I said, the statutory test is one of exceptional simpliciter, not exceptional and unforeseen. And another example that had been given, if somebody had a cancer of the knee and surgery, means, following surgery, that they had to have, special footwear. That's special shoes. That's an exceptional need, and you would qualify for the payment. But your department seems to be taking the view then that the next year, when you applied for, if you like, a follow-up for this exceptional need, because it has been, if you like, foreseen because of the earlier operation, that it won't be provided. So it is a very serious matter, I think, and I know that I think there's been a legal challenge in the High Court around this in recent days, where an effort is being made to bring the department, I think, back to the actual legislation that we have, and not to be erecting another hurdle. This is a very small amount of funding from the department. I think it has played an important role in my experience down through the years, and you have a long experience as well in this House, Minister, in alleviating real suffering for our citizens. And I've been disappointed in particularly the last 18 months, to find increasingly that this exceptional unforeseen rule is being used. So I'd ask you just to accept the amendment for the Consolidated Act to return the situation to the status quo ante these changes, and then to be able to proceed on that basis to deliver the exceptional need which may well have been foreseen, but to deliver it to assist our constituents. Thanks, Cathaoirleach.
Thank you, Deputy. Is there any other Deputy who wants to make a contribution to this? No? Minister?
Thank you, Cathaoirleach. And Deputy Broughan, thank you as well. I can't accept this amendment, but maybe I'll talk to you afterwards again, maybe about that if you have some cases, Deputy Broughan, you might bring them to the attention of the Minister, and she'll look at them for you. The legislation providing for exceptional needs payment is set out in Section 201 of the Social Welfare Consolidation Act 2005 as amended, and provides that exceptional needs payment can be paid to meet an exceptional need where an officer considers it reasonable, having regard to all circumstances of the case. The legislation does not confer a statutory right or entitlement to a payment. Principal consideration in making an exceptional needs payment is to address a particular once-off and exceptional need which is not expected to be a recurring nature and is therefore unforeseen. The Department has issued guidelines to staff administering exceptional needs payment to assist them in the decision-making process. However, this does not affect the discretion available to officers on issuing exceptional needs payment to assist an individual household in any particular hardship situation which may arise. And I think that's important, that word discretion, Deputy, because the officers on the ground know exactly each individual case. And I think they understand the cases that come before them as well. So that discretion is there. I think it's important that's used. Exceptional needs payment provides support for the most vulnerable, and to date, some 94,000 payments have been made, and has been the cost of €35 million. So 94,000 payments have been made, and as I said, €34 million covering varying needs from rent deposits to housing kit outs, clothing and travel. And I'm satisfied that the discretion available to officers in the administration of the scheme ensures these payments target those most in need of assistance, and the proposed amendment, I believe, is not required. As I said, if you have any individual cases of people that are in need like that, I would like you to bring them to the attention of the Department and to the Minister.
Deputy, you have the floor for a few minutes if you wish.
Well, I mean, I've done precisely that, and that's the reason I put down the amendment, Minister, without success. I mean, I know the Minister told me on November 7th, when I raised it with her before, that she says, yeah, as you repeat it here, that legislation doesn't confer a statutory right or entitlement, and the principal consideration in making a payment under the ENP scheme is to address a particular once-off and exceptional need which is not of an expected or recurring nature and is therefore unforeseen. But again, we would contend that the unforeseen aspect of it is illegal. We didn't put that into primary legislation. I'm not sure who the Minister would have been in 2005. Maybe Minister Ahern in that particular era, but that wasn't the intention, I think. And I think I feel myself, of course, with the Department of Social Protection's budget down through the years, that a primary consideration always is keeping it inside that 19-20 billion, even though we provide through our social insurance payments kind of half of that, but particularly in relation to any kind of assistance payments, that the finance is a huge consideration. And what I feel is that maybe the scheme, when it's needed more than ever, when we have such huge crises affecting families, families perhaps affected by homelessness, health difficulties and so on, that it is being further restricted. Now, you mentioned, as the Minister herself stressed on November 7th last, that obviously there is this discretionary power available. Many people think, of course, that the quasi-judicial powers that the Department has in relation to appeals and so on should be on a statutory basis. And when I was a spokesman myself in the past on social protection, that was something I tried to bring forward, the kind of enormous discretion and quasi-judicial power that people have and that are set out in legislation, but also expanded on in guidelines, can be very unfair. But the basic point I'm making is, and as I said, it is regrettable that you don't keep statistics overall on the applications, because it would be a very useful database for CSO and for our society generally. But the key point is that I think you're taking the 2005 Act and misusing it, I think, by adding a very key legislative provision, the word effectively this idea of being unforeseen, which wasn't in the legislation, wasn't intended, and which is new, and which this House should legislate for. And I would like it to legislate that it not be in the Act, and that the unforeseen idea be excluded. Thanks, Lascan.
Just briefly, when the Community Welfare Service came into the Department, there was a review at the time, and I would just say to the deputies, again, the review has been used, I suppose, as a basis for guidelines back in 2012-2013, and we obviously will keep the scheme under review and look at it again. To see does it support the people that it needs to support. As I said, it's important that the people on the ground, the social welfare officers on the ground, that they use their discretion in exceptional cases that you have mentioned there, because we know there are exceptional cases out there, because so far, as I said, 94,000 payments have been made in 2017, and that cost €34 million. So, the scheme has used, and it is a major cost factor, but it's important for people that are in dire straits, there's no doubt about that. And I would say to you, deputies, I said again, if you have particular cases, you could bring them to the attention of the Minister.
Thank you, Minister. You have the final right of reply if you wish. Okay. Are you pushing the amendment? Okay. So, I ask you to propose your amendment. Sorry? Propose your amendment?
Yeah. Amendment 3, yeah.
Those in favour, Aubrey Tá.
Tá.
Those against, Aubrey Neil.
Vote on.
I think that it's lost.
Vote on.
Vote on.
Yeah.